Your Excellencies, distinguished participants, it's my honour to join you and the UN Office on Drugs and Crime in celebrating the 75th anniversary of the Universal Declaration of Human Rights. The Universal Declaration gifts us a remarkable, uplifting vision for a social order founded on the sanctity of every human life. It recognises that rights and freedoms are fundamental not only to our survival and dignity, but to the flourishing of every individual within their communities. In times of crisis, conflict, and terrorism, governments are too often tempted to resort to extreme or excessive measures to combat security threats. Legal constraints may be brushed aside as seeming obstacles to protecting one's people from violence. Human rights and refugee law, international humanitarian law, international criminal law may all be perceived as somehow inadequate to meet security needs. Some governments pay lip service to international law while bending or breaking it in practice, often with the acquiescence of allies and sometimes with the full-throated backing of those parts of their populations calling for vengeance, not justice. Such challenges to legal constraints have been a long feature of campaigns against violence characterised as terrorism, from French Algeria and Northern Ireland to the global war on terror after 9/11 to current situations in the Middle East or West Africa. The present moment brings renewed risks to human rights in counter-terrorism because of surging domestic polarisation and political extremism, geopolitical competition, and new tools like social media for fueling dehumanisation, vilification, incitement, and misinformation. The 75th anniversary of the Universal Declaration is a timely reminder that human rights law has always taken a hard-headed and realistic approach to addressing security challenges. The Declaration itself sprang from the unprecedented tragedy of 80 million lives lost worldwide and many countries laid waste in the Second World War. As the UN High Commissioner for Human Rights recently said, the Declaration was crafted with lessons drawn from two global wars, the Holocaust, atomic destruction, profound economic devastation, and generations of colonial exploitation, oppression, injustice, and bloodshed. Having lived through such terrible suffering, the drafters of the Declaration were acutely conscious of the wide spectrum of security threats, both state and non-state actors. In Article 29 of the Declaration, they recognised that strictly defined limitations on rights may be necessary for security purposes. The possibility of derogation from rights in public emergencies was added in 1966 in the International Covenant on Civil and Political Rights. To exceed these carefully crafted exceptions is to betray a cardinal lesson of the war and the Holocaust, that human rights are so weighty and precious that they must not be too readily curtailed or sacrificed. The drafters of the Universal Declaration, like those of the UN Charter earlier, also knew firsthand that violations of human rights can cause conflict. The preamble of the Declaration observes that disregard and contempt for human rights have resulted in barbarous acts which have outraged the conscience of mankind. This sentiment is echoed today by the UN Global Counter-terrorism Strategy of 2006 in relation to the conditions conducive to terrorism. For the architects of the Universal Declaration, the structural antidote to violence was more, not less, protection of human rights, so that no one feels, quote from the preamble, compelled to have recourse as a last resort to rebellion against tyranny and oppression. The Universal Declaration is a clarion call that security and freedom are interdependent, not opposites. The UN Global Counter-terrorism Strategy and the UN Security Council and General Assembly likewise insist that respect for human rights is fundamental to effective and principled counter-terrorism efforts. Unfortunately, today, aspiration is not matched by reality in too many countries. The global proliferation of counter-terrorism law over the past 2 decades, including at the instigation of the Security Council, has placed enormous strain on the traditional rights-based principles and safeguards of criminal justice, which, commendably, UNODC has long championed. Sweeping definitions of terrorism and extremism compromise the principle of legality and infringe many fundamental rights. Wide and vague preparatory and organisation-based offences criminalise conduct and legitimate free expression, which has no proximate connection to the commission of terrorist violence. Organisations and individuals are abusively listed as terrorist without due process or judicial safeguards. Counter-terrorism sanctions and financing laws have undermined legitimate non-profit organisations, freedoms of association, assembly and expression, and humanitarian activities in armed conflict. Counter-terrorism laws are deliberately misused against political opponents and dissidents, the media, civil society, and minorities. Criminal procedure has also been undermined by counter-terrorism laws and practices, including through arbitrary arrests, protracted pretrial detention, torture and ill treatment, forced confessions, restrictions on legal counsel or rights of defence, non-disclosure of secret or classified evidence, the use of special courts, trials of children in adult courts, and the unlawful use of the death penalty. There's often also inadequate participation of victims of terrorism in legal proceedings and a lack of remedies for them. In some contexts, criminal processes allow too much impunity, as when amnesty laws are too broad or suspects are prosecuted for terrorist group membership or travel offences, but not also for the more serious international crimes that they may have committed. In other situations, criminal processes may over-penalise, as when repatriated women and children formerly associated with terrorist groups are not admitted to rehabilitation and reintegration processes, or former members of armed groups are excluded from disarmament, demobilisation and reintegration. Of course, a different problem is that many states have increasingly pursued measures against terrorism entirely outside the criminal justice system, in ways which can easily undermine it. Examples might include administrative preventive detention and post-sentence continuing detention, which challenge basic assumptions about the role of criminal adjudication and punishment. Protecting human rights and criminal justice responses to terrorism is not only necessary to safeguard the dignity of accused persons, it also enhances security because interrogations without torture and fair trials ensure the reliability of convictions and that terrorists are duly punished and incarcerated. It ensures law enforcement officials are accountable for their conduct and are thus more disciplined and focused in combating terrorism. It enables justice for victims who are best served by well-functioning criminal justice systems. It reduces the conditions conducive to more terrorism, lessons starkly illustrated by the irregular and abusive practices at places like Abu Ghraib or Guantanamo Bay. Protecting human rights ultimately distinguishes responsible states from terrorists who show contempt for rights and the rule of law. To conclude, celebrating the Universal Declaration is an opportunity for all of us to redouble our efforts to ensure that human rights are at the centre of counter-terrorism efforts, not at their periphery. Thank you.